Dealing with law enforcement can be a stressful situation. Mr. Shivarani may have felt that he was right not to hand over property he had paid for to those claiming it was theirs. However, it may have been more stressful when a couple of police officers showed up. This dispute began with a set of peculiar interactions between a jewelry store owner and police officers in Napoleon, Ohio. The jeweler, Jaska Shivarani, bought a ring for $45 from a petty jewel thief. The ring's rightful owners found out about the sale and asked Shivarani to return their property. Shivarani said no, so the owners contacted the police. Two officers, on a later visit to the store, directed Shivarani to surrender the ring to its owners, but Shivarani refused their request too, saying that it contradicted a letter he had just received from the police department telling him to retain the ring as evidence. And when repeating his refusal to another officer the next day, Shivarani suggested, for reasons unclear, that he was operating his store without a license. The result of that unprofitable exchange was that the police turned their attention from the original theft to Shivarani's business. This started as a dispute over who owned a ring and how that property should be handled. I'm not sure why Mr. Shivarani mentioned he was operating his store with a license, but perhaps that's an object lesson about chatting with law enforcement, something I do not do. Now, as a result of that utterance, the police stopped focusing on the original theft and turned their eyes to Mr. Shivarani's business. Now, soon afterward, the officers launched a criminal proceeding against Shivarani in municipal court. They filed 3 complaints, each charging him with a separate offense. 2 were misdemeanors, receiving stolen property and dealing in precious metals without a license. The third was a felony, money laundering. Now, after a criminal investigation, 3 complaints were filed against Mr. Shivarani. First, receiving stolen property, a misdemeanor related to the original dispute. Second, dealing in precious metals without a license, another misdemeanor which logically came from Mr. Shivarani's utterance about his business. Last, and not only most serious but most important, felony money laundering. To support their accompanying application for an arrest warrant, the officers submitted an affidavit making the case for probable cause on all 3 charges, but focusing on the felony. For that charge to succeed, Shivarani must have known when he bought the ring that the transaction involved the proceeds of an unlawful activity. Since a warrant requires probable cause supported by oath or affirmation, the application for an arrest warrant included an affidavit. This is required by the 4th Amendment, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The warrant requires an oath or affirmation that the probable cause is true. So what was in the affidavit the police used to get the arrest warrant? In support of that element, the officers averred that Shivarani always suspected the ring was stolen. The judge issued the requested warrant and the officers arrested Shivarani. He remained in custody for 3 days until his arraignment. Now, the officers claimed that Shivarani always suspected the ring was stolen. This was a necessary component of the money laundering charge. But how did the officers know that Mr. Shivarani suspected the ring was stolen? See, the details matter, especially in a criminal case. Suspecting that something is stolen isn't the same as knowing it. Based on the affidavit, the judge issued the arrest warrant. The officers arrested Mr. Shivarani, who then spent 3 days in jail awaiting arraignment. At a latter preliminary hearing, the judge heard testimony about the evidence supporting the officers' probable cause allegation. The officers maintained that Shivarani had admitted in their interview to suspecting the ring was stolen. Shivarani denied making any such statement. So it turns out that when it came to admitting that Mr. Shivarani knowing the ring was stolen, it was the word of the officers versus Mr. Shivarani. Now, the officers did have to swear or affirm under penalty of perjury that their testimony was truthful. But does the word of a couple of officers without any evidence rise to the level of probable cause? In fact, isn't their assertion that Mr. Shivarani admitted something hearsay? Shouldn't this interview have been recorded, meaning there would be a record of Mr. Shivarani's admission? At the hearing's conclusion, the judge again found probable cause and set the 3 charges for trial. As flimsy as this affidavit is, the hearing judge found probable cause and sent the case to trial. However, the county prosecutors seemed less than enthused. The county prosecutors, though, decided that they had higher priorities. They failed to present the case to a grand jury in the required time. The court therefore dismissed the charges. See, in order to indict Mr. Shivarani for the felony, The case had to be presented to a grand jury for indictment. However, the county prosecutors didn't bother. When the time limit for the prosecution to file expired, the judge dismissed the charges.